The judicial system is designed to disregard emotion, but that doesn't mean emotion doesn't come into play, as in a recent court ruling changing juvenile sentencing. Following the lead of the U.S. Supreme Court, the SJC ruled mandatory life sentences for juvenile murderers are unconstitutional. The decision set the minimum time served at 15 years, and now the families of some murder victims are making an impassioned plea to keep those killers locked up longer. Many of the cases involving juvenile murderers are related to drug and gang violence and are sadly anonymous. But some cases have gotten a lot of attention, like John Odgren, the Lincoln Sudbury High School student convicted of murdering fellow student James Allenson in 2007. Odgren, then 16, got life. Same with Eddie O'Brien, who killed his neighbor Janet Downing in 1995, when he was just 15. In fact, that was the case that changed the law, requiring so-called super predators to be tried as adults. Now, with the new court ruling, some families and legislators want to make sure juvenile murderers don't get parole too early. Senator Bruce Tarr is co-filing legislation on behalf of the Brody family. Their daughter, Beth, was beaten to death by 16-year-old Richard Baldwin in 1992. Tarr's new bill would ensure that Richard Baldwin serve at least 35 years before becoming eligible for parole. I'm joined now by Beth Brody's brother, Sean Alward. Thanks for joining us, Sean.
Thank you.
Tell me what you remember about your sister. How old were you when this happened?
I was 21, recently married, moved away from home before that, and I was called after work one evening with this horrible, horrible news.
What was her relationship with Richard Baldwin?
They were schoolmates, classmates. He had wanted a romantic relationship. At that age, romantic relationship was maybe they sat together at lunch. But some would like to say they dated. They did not. She did not.
So how many years has he served now?
He served 21 years.
Yeah. So under the new ruling of the SJC, he would have been eligible for parole 6 years ago already. What is it about the new sentencing guidelines that bother you? Because there's no guarantee that he would get parole. It's just that he would get a hearing.
Well, what gets to us is the fact that we were told he was going to prison for the rest of his life with no chance at all for parole. Judges had made that decision, and they put him away. They used the harshest penalty available to us at the time. And now they want to take it all back and bring us all back through this horrible, horrible story. Mm-hmm. And it just doesn't seem right that they have to do that, not just our family, but to all the other families involved.
Now, Bruce Tarr and another legislator have filed this bill that would make 35 years the cutoff, so he could get parole at 35 years. Would that be suitable for you?
It's a great first step. The 35 years does not work retroactively, so really it would not affect our case at all. It's going to affect cases going forward, which had Massachusetts interpreted the SJC ruling in the same way, we wouldn't be in this position right now. It's fine to change the law going forward, but to dig it up into the past is ridiculous.
Well, how do you respond to some that say, look, people 15, 16 years old don't have fully developed minds. They clearly know the difference between right and wrong, but there have been some horrible cases of killing for fun. There have been cases of killing for emotional reasons, but a more thoughtful, more mature individual wouldn't have done it.
I'm not all that familiar with the other cases. I'm very familiar with our case, obviously. In our case, he clearly knew right from wrong. It was a premeditated murder. There's no question whatsoever that he should get the harshest penalty. As far as an underdeveloped brain, it doesn't apply to this case at all.
Then why do you need a law to change it? Because if that's the case, because they have to prove in the state anyway that the individual had a juvenile brain, which seems like a tough thing to prove. But if you think in this case Richard Baldwin was already beyond that, then it really wouldn't affect your case.
It's not going to affect our case. When our case happened, we actually had to go through a transfer hearing. So there was already a judge, and the court system determined that this was an adult-type decision for an adult-type crime. Therefore, he got an adult penalty.
There's another terrible case that just happened in the fall of last year. Danvers school teacher Colleen Ritzer was allegedly murdered by one of her students. Now, he, too, was 15 or 16. I can't remember. I think 15. Do you think the same standard should apply to him, or is there possibility that he has some juvenile brain issues?
I think that it should be left up to the judges in all of these cases, whether we're going forward or going backwards. leave it up to the judge to reserve that penalty for the most atrocious crimes. I think it's not right for a judge to have to make a decision without that penalty at hand.
Have you been in touch with the Ritzer family about this new law that Bruce Tarr is proposing?
We have heard from them. We haven't actually spoken with them.
All right. Sean Elwood, thank you so much for telling your story. Appreciate it.